So SEBI compliance applicable when the corporate debtor is a listed company. SEBI regulations applicable during CIRP of a listed company. So this is a complete guide for successful resolution applicant. They should aware of this. So welcome back to RR Legal Talks. We have two channels, RR Corporates and other channel RR Legal Talks. So if successful resolution applicant acquiring a listed company under the Insolvency and Bankruptcy Code, so your responsibility does not end with the approved resolution plan by Honorable NCLT. So many resolution applicants focus only on the IBC. However, once the corporate debtor is a listed company, so the successful resolution applicant must also comply with the several SEBI regulations, stock exchange requirements, and depository compliances. Failure to comply result in penalties, suspension of trading, regulatory action, delay in implementation of the resolution plan. Today we will discuss the important SEBI regulations every successful resolution applicant should know. The first one is SEBI LODR, Listing Obligation and Disclosure Requirement Regulations 2015. This is the most important regulation. After implementation of the resolution plan, the listed company must continue to comply with board composition, independent directors, audit committee, NRC nomination remuneration committee, stakeholder relationship committee, related party transactions, quarterly financial results, annual report, corporate governance report, material event disclosures, website disclosures. So during CIRP, certain governance provisions are relaxed because the resolution professional RP performs the functions of the board. After implementation, the reconstituted board must restore full compliance. And another regulations, SAST regulations, SEBI Substantial Acquisition of Shares and Takeovers Regulations 2011. Normally, acquisition of control acquires an open offer. However, shares acquired under an NCLT approved resolution plan are granted specific exemptions. So under takeover regulations, so certain exemptions are there. The facilities, implementation of the resolution plan without following the normal open offer process, so that is the relaxation is given. SEBI ICDR, Issue of Capital and Disclosure Requirement Regulations, where fresh equity shares are issued to the successful resolution applicant under the resolution plan. Preferential issue provisions, pricing norms, lock-in requirements. These are all subject to special framework applicable to CIRP cases. Another PIT regulations. Throughout the CIRP, sensitive information exists regarding the resolution plans, bidders, valuations, financial positions, implementation. So therefore, all insiders must strictly comply with insider trading regulations. Trading while in possession of unpublished price sensitive information is prohibited, UPSI. Another regulation, SEBI Delisting of Equity Shares Regulation 2021. If the resolution plan process delisting, special provisions under the delisting regulations become applicable. The resolution plan should specifically provide the manner of delisting, exit to public shareholders wherever applicable, and compliance with SEBI framework for CIRP cases, and minimum public shareholding, that is MPS. After implementation, the resolution applicant may acquire a very high percent of shares. If public shareholding falls below the prescribed minimum, the company must restore minimum public shareholding within the time permitted under the SEBI framework. This we have discussed in another video in detail. And then stock exchange disclosures. This is important. CIRP events are required to be disclosed to the stock exchanges. So including admission of CIRP, appointment or reappointment, RP, IRP, COC decisions where required, approval of the resolution plan, implementation of the milestones, change in the management. So promoter reclassification. Generally, existing promoters cease to be a promoters after implementation. So SRA, Successful Resolution Applicant, usually becomes the new promoter group. So necessary filings or disclosures must be made in accordance with the SEBI requirements. Then board reconstitution. Immediately after the implementation, the new management should appoint the directors, appointment of independent directors, KMPs, constitution of board committees, and appointment of compliance officer, and corporate governance compliance. The company should ensure audit committee, NRC, stakeholder committee, risk management committee, wherever applicable, and internal auditor, secretarial auditor. So all statutory compliances. Share capital changes, where the resolution plan provides for cancellation of existing shares, issue of fresh issue shares, a reduction of capital, consolidation, and preferential allotment. So necessary corporate actions should be completed through the depositories and stock exchanges. And DMAT, depository compliances. So successful resolution applicant should aware of all these things. Coordinate with NSDL, CDSL, and registrar and share transfer agent, RTA, for the implementation of new allotments, ISA and updates if required, and corporate actions, promoter classification, and disclosures of shareholding pattern. So after implementation, the revised shareholding pattern should be filed with the stock exchanges within the prescribed timeline. And quarterly, annually compliances. The revived company must resume regular compliance relating to quarterly results, annual report, corporate governance reports, and investor grievance reports, and also should know investor relations. The new management should establish investor relations mechanism. Shareholder communication, also compliant redressal mechanism should be there. Website update should be there. Then there should be a checklist for successful resolution applicant, like before implementation, ensure resolution plan complies with IBC. Resolution plan considers SEBI regulations. Corporate actions are planned. New board identified. Independent directors are shortlisted. Compliance officer appointed. Secretarial auditor is appointed. Stock exchange filings are ready. Shareholding pattern is updated. MPS compliance plan is prepared. Insider trading and insider trading code is implemented. So policies required under LODR are adopted. So when the corporate debtor is a listed company, the resolution applicant must comply with both the Insolvency and Bankruptcy Code and SEBI regulatory framework. This is the most important. So a successful resolution is not only about the obtaining honorable NCLT approval, it is also about ensuring a smooth post-resolution compliance with the applicable SEBI regulations, stock exchange requirements, and corporate governance standards. So understanding the compliances in advance help the successful resolution applicant implement the resolution plan efficiently and avoid regulatory issues. So this is a very important topic. Hope you are clear. Thank you.